2023 at approximately 10:03 in the morning, and this is the time and date set for the recall hearing in case number PZC 22-0031 regarding respondents OFP and Hannah Alvarez. We did have a hearing on September 7, 2023, where Ms. Alvarez was present on behalf of the respondents. Testimony and evidence were taken and an order was issued on September 12, 2023. Among other things, there were findings and conclusions made in that order that there were 4 zoning code violations on the subject property, and a compliance date was set for October 7, 2023, that being the date that was given to Ms. Alvarez for the property to come into compliance. The order also set forth a number of consequences if the property was not in compliance by the date of October 7, 2023. Additionally, a hearing was set for today so that we could follow up and determine whether the property had been brought into compliance or not. Mr. Stento, you're appearing on behalf of the complainant county?
That is correct.
And can you confirm whether respondents have a representative with us today, either in person there at the county building or online or on the phone?
The respondents do not have a representative in person or on the phone or on the Teams.
Okay. Are you planning on testifying today, Mr. Stento?
Yes, sir.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in your testimony today?
I do, sir.
Mr. Stento, why don't you go ahead and testify, and among other things, please tell me whether or not respondents were served with my order on October 7th, and also tell me whether or not respondents have brought the property into compliance.
Yes, sir. Before I begin, I'm going to share my screen so you have some exhibits up.
Thank you.
And I'll get to these in a minute, but addressing your first question, formal service occurred via certified mail on 18 September. Prior to that, we made a service attempt in person on the property on 12 September at 1,307 hours. We did not find anyone at the property. I spoke with Hannah via phone call on 14 September. And at that time, while it does not constitute service, I did send a copy of that order as well via email to Ms. Alvarez and explained in the conversation that the order had been issued and that she would be well advised to review it. She noted she would at that time, and that was the extent of the conversation. Prior to that, I did speak with her about some options to bring the property into compliance, specifically the metal storage containers. I told her with the metal storage containers, if she cleaned up the rest of the property, we would consider allowing her to deal with those via temporary use permit, even though they had been modified pursuant to the metal storage container section of the zoning ordinance that would have given her a much lower cost option to deal with that specific issue.
Mr. Stento?
Yes, sir.
Hold on one second. I just want to make sure. I just want to confirm what I think I heard you say about service. So did you say an in-person attempt was made on September 12th? And was that by you?
That's correct. That was by me, September 12th at 1,307 hours.
And no one was present on the property?
That's correct.
Did you leave anything? Did you leave the documents at the property at that time?
We did not leave the documents at the property.
Okay, and then on September 14th, you actually talked to Ms. Alvarez by phone?
That's correct.
And you told her about the hearing?
That's correct.
Okay, and then you also emailed a copy of my order to Ms. Alvarez on September 14?
That's correct.
Okay, and then you sent it by certified mail on September 18, as I see on the screen?
We had sent it prior to September 18, but that was when it was served. We sent it via certified mail immediately on issuance of the order.
Oh, okay, gotcha. I see.
It just took them a little while to collect it.
Okay, thank you for clarifying. So do you recognize the signature of the person, the signature or name of the person who signed the green card?
I would have to review the previous certified mail receipts to either confirm or deny that. I don't know the signature of the respondent or respondent's family well enough. It does look familiar when compared to the other certified mail receipts, but that's
Okay.
anecdotal.
Okay. I'm sorry to have interrupted your testimony. You were then saying that you talked to her about the MSUs.
Yes, sir. And do you have any other questions before I proceed?
No, thank you.
Yes, we talked to her about options for the metal storage containers. We placed an emphasis on cleanup of the property. And then the RV can be dealt with at least temporarily via temporary use permit. On a follow-up visit to check for compliance after service had occurred in late September. I don't have the date in front of me. We did not find Hannah at the property. We were just checking up on it while we were working in the area. We did notice an unidentified male standing on the roof of the RV and doing some sort of modification to it. We were not sure what was going on. Code Enforcement Officer John Cole visited the property yesterday, 9 October 2023. Walked the property, took photos and video while doing so. We noted that the violations were substantially unabated. In fact, we noted very little change to the property. In Exhibit A, or 1A, excuse me, we can see the RV basically still there, unmodified. We presume that it continues to be in use as a dwelling, especially after seeing it being worked on by, again, that unidentified male at the time the site visited. On the property, we still see unscreened storage of secondhand materials, again, substantially unabated. We can see the metal storage containers in the background. They remain present. This gives us a better view of the ventilation of the door installed. We did confirm with building division that the second you cut into a metal storage container, it requires a building permit. So these are essentially unpermitted structures. Significant amount of tires on the property. Tires are specifically regulated under the county storage and screening standards. This again is of course on the property during the benign October walkthrough. Another view of an additional array of materials, secondhand items, construction materials, trash, and the storage containers as well. The unregistered water tanker, one of several unregistered vehicles on the property, none had been removed, unregistered or inoperable vehicles. Another view of the property.
Mr. Stento?
Mr.
Yes. Stento, that water, will you go back to the water tanker?
Yes.
So I know that was, we talked about that before. I do see it has a license plate on it. How do I know that it's not registered, not operable, etc.?
The vehicle hasn't moved in the time we've been pursuing this case. The tags haven't been updated at all. The plate is a farm vehicle tag that hasn't been issued by the state of Arizona for a very long time. The vehicle does not appear operable. It does not host a current registration. And the respondent has had numerous opportunities, if the vehicle were registered and operable, specifically registered, to provide us directly with that information, has failed to do so.
Thank you.
Yes. Another view of refuse scattered about the property. These are two vehicles that have not moved. since we've been visiting the property, as well as a pile of stuff, tires, propane tanks, other items that are regulated again under the county storage and screening standards. This Subaru with California tags is missing the tire and actually it hasn't moved during our numerous site visits to the property. So again, we see the violation substantially unabated, no significant change to the property. I asked that exhibits 1A through 1H be admitted into evidence.
They're admitted.
Thank you, sir. And we ask that the county's request for relief be upheld.
Okay, I will also admit, that's exhibit 1 that shows the green card?
That's exhibit 1, yes, sir.
Okay.
Thanks.
So all of your exhibits, they were 1A through 1H and 1?
That is correct. 1 through 1H.
Okay, they're admitted. Did you make any attempt to provide those to respondents before today?
I emailed them to the respondents this morning.
Okay. Hold on 1 second. Sorry, my pen died.
Oh, quite all right.
Okay, exhibits 1 and 1A through 1H are admitted. Okay, so in the prior order, in paragraph, I'm sorry, on page 10, in paragraph 3 and 4, I set out the judgment of what remedy would be ordered if the violations were not abated. I'm going to find and conclude today that the violations have not been abated, and therefore I'm going to implement the remedies that were set forth in paragraphs 3 and 4 on page 10 of my previous order. And I will issue a written order laying that all out, and that'll be forthcoming.
Thanks, sir.
Is there anything further, Mr. Stenta?
I have nothing further.
Pardon?
No, sir, the county has nothing further.
Okay, we stand adjourned. Thank you very much.